Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was accused of assault. Assault attorneys, Oakland. Assault lawyer, Oakland. Criminal lawyer, Oakland. Criminal attorney, Oakland. Let's see. One night in a street, I wanted to talk to my ex-girlfriend. She put a restraining order on me. That night, she didn't want to talk to me and accused me of assault with a deadly weapon because I carried a penknife. Well, generally speaking, it's perfectly legal for you to be in possession of a knife as long as it's under 2 inches. Now, if the knife is, whether the knife is under or over 2 inches, if it's the type of knife to where like a switchblade, you push the button and it flips out, then no, you can't carry that, and you could be charged with, I believe it's a, let's see, the code right now is escaping me at the moment, but you can be charged with being in possession of a weapon. So you don't want to do that if it's a switchblade or if it's more than 2 inches long. However, obviously, if you approach somebody with a knife and they legitimately believe that they are in, they are in fear of great bodily injury or death, in a situation like that, you could be charged with assault with a deadly weapon, which would be a violation of Penal Code Section 245, parentheses A, parentheses 1, which carries up to 4 years in state prison, and you could actually get a strike for that. In a situation like this, the other issue is a restraining order, because let's just forget about the whole assault with a deadly weapon. If there's a restraining order and you violate that order by getting close to your alleged victim here, well then you'd be in violation of a court order, which would potentially be a violation of Penal Code Section 166, parentheses A, or it could be a violation of Penal Code Section 273.6, which both carry up to 1 year in county jail. So in a situation like this, we really have to see if there are any witnesses that could testify as to what really happened. Now, in a situation where there's a restraining order and the victim wants to talk to you, still can't have contact. You have to get permission from the court. In criminal court, you have to add the matter on calendar, or rather the victim has to add the matter on calendar to talk to the judge to get a modified order so that at the very least you could have peaceful contact. And if you're going to do that, or rather if the victim's going to do that, she's probably going to have to take some classes for the victims of domestic violence in order to satisfy the court that she is aware of the risks that she is taking by being in contact with you. But you have to be very, very careful when there is a restraining order against you. Do not approach, do not talk to the victim, not even by way of a third person unless you have permission from a judge, or if you're doing this through an attorney because you have some kind of emergency and you have to be in contact with the victim, which usually happens in situations when they have children in common. Regardless, if you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of a crime and need representation in court, give us a call at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the destruction of property. Remember, assault attorneys, Oakland. Assault lawyer, Oakland. Criminal lawyer, Oakland. Criminal attorney, Oakland. See you on our next video.